Welcome back. Attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Let's talk about another recent court case that has implications in the estate planning and real estate worlds. Today we're talking about a Supreme Court decision, but not a decision on a case, but a decision not to hear a case. The Supreme Court turned down a case that challenged New York City's rent control laws, leaving the lower court's ruling in place and thus allowing some far-reaching implications for property rights and housing policies across the nation, which means us here in California need to pay attention. Rent control has long been a contentious issue balancing tenants' rights and landlords' property rights. This recent decision underscores the legal and constitutional debates surrounding these policies. So let's dive into the details of the case, its significance, and what it might mean for the future of rent control in the US. Don't forget to hit the like button, subscribe, share the video with someone who loves private property or who's a rent control fan. And let's get into it. The case is 74 Pinehurst LLC versus New York. A group of New York landlords brought forth a property rights challenge against the city's rent control laws, arguing that the combination of rent regulation and the tenant's long-term occupancy rights effectively constituted a taking of private property without just compensation, thus violating the Constitution. For a quick constitutional law lesson, the Fifth Amendment prohibits the government from taking private property for public use without the payment of just compensation. There are tomes and tomes of case law on what exactly is a taking within the meaning of the amendment. You have a physical taking, which is pretty straightforward. The government occupies the property in total or in part. You have a total regulatory taking, wherein a government regulation renders property economically inviable in total. An example is if you bought a piece of land to build a house, but a regulation was then put in place restricting development in the area, meaning your land is effectively useless. And last, you can have a partial regulatory taking, wherein a government regulation affects some economic use of the property, but there still remains some economic use, taking into consideration a few factors. Of course, the plaintiffs here would be arguing a partial regulatory taking. They may still rent out the property and make money from the arrangement, but due to the regulations, they aren't able to effectively control how that arrangement ultimately plays out. Think of it as if you're free to contract with someone to fix up your yard, but the government sets the pay rate and the work schedule. That's not a one-to-one example, but enough that you understand the thought process. The Supreme Court, however, decided not to take up the appeal, effectively leaving New York's rent control laws in place. Notably, Justice Clarence Thomas expressed a partial dissent, emphasizing the importance of addressing the constitutionality of such regulatory regimes, but also noting that the landlord's failure to provide specific evidence of being prevented from evicting tenants under certain conditions. Essentially, yes, you do have to comply with many regulations, but there needs to be a demonstration that those regulations impose such a burden that we could argue it's a taking under the Fifth Amendment. This decision was closely watched as it held the potential to affect over 1 million rental units in New York City alone, not to mention its broader implications for similar rent control laws across the country, especially in California. The California Apartment Association, representing landlords and property owners, had urged the justices to hear the New York case, highlighting how a ruling could impact rent control laws in major Californian cities. Rent control policies have traditionally been upheld under the premise that they regulate property rather than seize it. However, with the Supreme Court's conservative majority showing recent interest in strengthening property rights, many speculated whether a shift was imminent. Been a few of those lately. This decision arrives amid a broader context where the Supreme Court has shown a willingness to bolster property rights, such as striking down a California law related to union organizers on farms in 2021, asserting private property owners' right to exclude others. They disallowed union organizers to go onto farms in order to recruit potential members. While the Supreme Court's refusal to challenge New York's rent control laws maintains the status quo, it also signals a cautious approach to reinterpreting property rights in the context of housing regulations. For landlords and tenants alike, this decision emphasizes the ongoing balance between providing affordable housing and upholding property owners' constitutional rights. As we continue to navigate these complex legal landscapes, it's crucial for property owners and renters to stay informed on the evolving legal standards and regulations governing rent control, not just in New York and California, but nationwide. Just in case you missed it, we recently published a video on the statewide rent control law that was put in place back in 2019 called the California Tenant Protection Act of 2019, also known as Assembly Bill 1482 or simply AB 1482. AB 1482 imposes a statewide rent control regulation wherein the amount a landlord is able to increase the rent by within a year is capped, among some other regulations. There are, of course, exceptions and factors to consider, but you'll have to watch the video yourself for all the juicy details. But back to today's ruling. This Supreme Court decision marks a significant moment in the ongoing debate over rent control and property rights. As we look to the future, questions remain about how jurisdictions will navigate the delicate balance between affordable housing and property owners' rights. What are your thoughts on this decision and rent control laws in general? Do you believe there's a fair balance between tenants' protection and landlord rights? Share your thoughts and opinions in the comments below. Be sure to like and subscribe, share the video with someone you know who loves private property or who's a big fan of rent control. I'm attorney Andrew Bethel, and I'll see you next time.